Well, the battle between church and state actually first started probably on day one of the British colonization of North America. There's a long history of interaction between the religious and the temporal realms within our history, and it has continued to this very day. This year, 2014, there are 2 church-state cases before the United States Supreme Court. So these matters are litigated quite frequently and have been a constant issue in American history. What I study on in this book is about prayer and Bible reading in the public schools, and then the complementary issue about the funding of religious education. Today, we see these as 2 distinct issues, and when the United States Supreme Court has dealt with these cases since the 1940s, they have dealt with them in 2 separate categories. But historically, they were closely interrelated. And so I look at both of those because those are by far the dominant church-state issues of the 19th century, even accepting that the battles over the Mormon Church in Utah were very prominent issues. The prayer and Bible reading in the schools and the funding of primarily Catholic education in the 19th century was the issue. In fact, it was so crucial that it actually had its own name. People called it the school question, and everybody knew what that meant. That meant this question about how religious should public education be, and whether we should be funding non-Protestant alternatives to public education. It came to a head in an attempt for a constitutional amendment after the Civil War. There were battles in the streets over this issue. There was a riot, 2 riots actually, in Philadelphia in the 1840s over Bible reading in the public schools. It was a highly contentious issue. The practice of prayer and Bible reading, which really arose with the advent of the common schools in the first part of the 19th century, that initially it was highly religious, highly Protestant. But over time, due to a variety of pressures within the nation, immigration being the primary pressure, but more even internal pressures, that it became less and less religious, more and more rote, more and more for actually trying to justify it on non-religious grounds many times. And greater opposition was arising, not just from Catholics about prayer and Bible reading in the schools, but from a growing number of secularists, Jews, even moderate to liberal Protestants were starting to see that prayer and Bible reading in the schools was not consistent with constitutional principles. And so there was a very strong debate going on about this in the 19th century that is kind of mirrored by what's today about this issue. So in essence, there wasn't a consensus. Well, there was somewhat of a tension on what the Catholics and the other groups wanted to see. Initially, Catholics and Jews and other religious minorities, initially they objected to the very highly Protestant-oriented Bible reading and religious exercises in the public schools. So as a result, many public schools, predominantly in urban areas, the school boards made the decision to either, usually first, just to water them down. They would get rid of catechisms, they would actually get rid of the highly sectarian nature of some of the readings they would do, and would fall back on what they thought were more consensus readings, reading from the Psalms, reading from Proverbs or whatever, those books of the Bible that they thought everyone would agree to. To their surprise, because most of them were not really that aware of Catholic theology, that didn't satisfy the Catholics either, because the Catholic Church believed that children needed to be directed in what they were reading. They needed the intermediation of a priest when it came to Bible reading. And so they actually disagreed with any type of religious exercise in the public schools that didn't involve a priest. Well, that, of course, was not going to occur in the public schools because they were seeing the incursion of Catholics within America as being threats on so many levels. And the idea of bringing a priest in the public school to do prayer and Bible reading for Catholic kids was going to go crazy. And so what happens is that these are almost like ships passing in the night. Neither side really understands the other side's argument. The evangelical Protestants are just holding on to prayer and Bible reading, King James Bible, with their last gasp. The liberal and moderates are saying, we can accommodate the Catholics, just tell you what you want. We'll water them down a little bit more. Or in many school districts they said, we'll even get rid of them. But the Catholics were saying, wait, no, we think religion has to be crucial for education. You can't separate these two. And so consequently, our response is we either need to have the readings of the Catholic Bible under the direction of a priest in the public schools, or give us money to fund our own parochial schools so we can have an integrated religious education. And neither side could actually see the merits of the other side in this debate. And it was, again, highly contentious, and it tore apart communities throughout the 19th century on how to resolve this issue. The Supreme Court first entered this debate about school prayer in 1948 in a case dealing with what's called release time. And release time was actually an interesting modification to try to respond to the complaints about school-sponsored prayer and Bible reading in the public schools as a way of kind of accommodating all groups. Some ministers, I think starting Gary, Indiana in the early 20th century, said, I know what we'll do. Let's actually not have the schools be responsible for religious education. Let's put aside a time during the day, and we will allow each religious community to bring in one of their teachers or ministers to the children of that faith and do religious education on site. That became a rather common practice in the first part of the 20th century and did not completely replace prayer and Bible reading. Prayer and Bible reading remained relatively active in the South. But in the North and the West, that became more common to have this release time. The Supreme Court heard a case on that in 1948, which is the first true modern Supreme Court case dealing with this issue. And they found that to be unconstitutional because they said it was still too close a relationship between the schools. The schools were promoting release time, and in some communities, it became basically indistinguishable from the public schools just promoting religion. 4 years later, the Supreme Court reversed itself and said we can have release time so long as it takes place off campus, like at a church across the street. And that actually is still the law today, that you actually can have children released from public education to go off campus to receive religious instruction. It's optional with school districts. But that was the first case. The seminal cases were in 1962 and 1963, which addressed the core issue, which was a non-sectarian and relatively nondescript prayer that would be read over the public address system, or just reading of the Bible without note or comment was the way it was called in essence. No commentary, you just read the Bible, and then maybe have the Lord's Prayer or something like that. Again, the feeling is these are kind of those universal aspects of religion that all, at least Christians, can agree with. But the Supreme Court still, very definitively, in 8-1 decisions, came down and said, no, that's unconstitutional because it's still school-sponsored, school-directed religious exercises.
The first question at President Kennedy's news conference deals with the Supreme Court decision that a New York school prayer violates constitutional separation of church and state. The President's statement is in the nature of an effort to calm the storm over the decision.
Well, I haven't seen the measures in the Congress, and you'd have to make a determination of what the language was and what the effect it would have on the First Amendment. The Supreme Court has made its judgment. A good many people obviously will disagree with it. Others will agree with it. But I think that it is important for us, if we're going to maintain our constitutional principle, that we support Supreme Court decisions even when we may not agree with them. In addition, we have in this case a very easy remedy, and that is to pray ourselves. And I would think that it would be a welcome reminder to every American family that we can pray a good deal more at home, we can attend our churches with a good deal more fidelity, and we can make the true meaning of prayer much more important in the lives of all of our children. That power is very much open to us.
And that's continues to be contentious today. I actually grew up in Texas, and more than 12 to 15 years after the school prayer decisions, my high school was still having prayer and Bible reading over the public address system. And so many states and school districts resisted that because they saw this as being so crucial to at least teaching a limited degree of religion to children, and more importantly, morals and character education associated with that. I think this issue has lasted so long is because we do still have some relatively religious homogeneous communities, but it's becoming less and less. And to a degree, we like to see our government represent our values. And particularly if we're talking on a community level, a local level. The school board is, in fact, your neighbors, your friends, and they're reflecting the values of the community. And there are many communities that wish to have the public schools do more than just kind of the rote. They want them to teach morals. They want to teach character education. And for many well-meaning people of faith, you can't teach character education without teaching the religious origins of it, the religious aspects of it. That's what makes character and moral education really matter. So a lot of people see it as really causing no harm and doing a fair amount of good. They also do see many times that it's kind of the greater society imposing its values on a local community. I litigated these cases for about 10 years, and I remember several times where I'd go in and talk to school boards that tell them they couldn't continue with the practice or was actually involved in lawsuits, that people in the community would say, "Why are you doing this? Everybody likes this practice. Everybody thinks it's a good idea. No one's ever complained before." And you start kind of peeling back the onion and you look a little bit closer, and you can actually find there have been people who've been objecting to this practice for many years in the past, but they had always been marginalized by the majority of people within the community. So in that sense, it's a combination of this need to kind of reaffirm community values, but also many times seeing things like what that evil Supreme Court is doing back up in Washington is it's posing its values on our community. There has been an argument that some people are overly sensitive to any manifestation of religiosity in the culture. And I think that argument has some merit to it. Conversely, though, there are many parts of the country where religiosity is very prominent. Outside the Capital Beltway, outside some major cities, you'll see a large number of churches. You'll see a large number, many times, of signs, billboards with some type of religious quality to it. Religious messaging occurs quite frequently. And so there is that presence of religion that already exists in public life. And except the hardline, extreme atheist on one extreme, maybe who would say, we don't want to see any of that. Vast majority of people see no problem with that. It basically becomes a question of whether there is a de minimis rule when it comes to constitutional violations, whether some things should be seen as just not that crucial in order to ensure that we maintain a healthy separation of church and state. And to a degree, I think there are some practices that, as a litigator, as a lawyer first, that are just not worth litigating many times. And some people can go overboard in their offense to a degree of religiosity in society. But conversely, we should never presuppose just because something for me is religiously acceptable and not religiously offensive, that it is not for somebody else in our community. I mean, Justice Sandra Day O'Connor, who retired on the court, I think in 2005, 2006, one of the most important principles that she advocated in advance, and she'll be known for this long after she dies, is that she basically said one thing that the First Amendment was directed to do was to make sure that people don't feel like they are outsiders in the political community and not full participants in the political community because of their religious beliefs. That we need to ensure that we don't endorse religion in ways that make some other people feel like you're favoring someone else's religion over my religion. Now, for some people, there's a zero-sum game. If the government isn't celebrating or recognizing religion at all, then you're denigrating religion. I tend to disagree with that typology. I think that actually there is a middle ground where the government can be truly neutral about religious issues, not disparaging religion on one side, but also not promoting religion on the other side. And one thing we have to keep in mind is that we are the most religiously diverse nation on earth. We have, depending on your count, as many as 1,500 different faith groups and religious traditions within the United States. There are more Muslims in America than there are Presbyterians, Episcopalians. I mean, it's next to Baptist, Catholics, and Methodists. They're right there. And so we are seeing just a greater religious diversity within this nation. And we need to ensure that no one feels like that they are not a full participant, not a full citizen, because of their religious beliefs. It's quite easy for me as a Protestant to say, no one should be offended by certain representations of my faith tradition, because to me it's just so normal, it's so accepted. But there are many people out there who may see it very differently, and we have to be sensitive to that. I would like for people to take away from this book that they understand that these debates about church and state are complex. They have a long history, and that there has never really been a consensus view about what the proper relationship between church and state should be. And when they see people, whatever, either objecting to certain manifestations of government involvement with religion, that they need to realize that no one has the right to claim a prior advantage on matters of religion. That there should be no default out there of one religious preference over another religious preference. And the battle over prayer and Bible reading in the schools is the best example we have of how we have fought through that principle, have worked through that principle, trying to understand, because this was one of the things about the 19th century, is that the public school educators could never understand the Catholic complaints. They kept saying, wait a minute, why would you find this objectionable? It's something that all Protestants agree on. And the Catholics say, well, that's the point. We're not Protestant. This is not something that we find a common ground on. And so we need to realize that we have a growing religious diversity, far exceeds what existed in the 19th century. And we need to be sensitive to the minority religious communities. And some people may say, well, that's, disparaging Protestants or evangelicals within America. But at least in my study of church and state, American religious history, and constitutional law, and in my practice, those normally aren't the groups that need the protection of the Constitution. It's the religious outsiders, if I can use that term, who need the protections of the Constitution. And that's what the Constitution needs to be sensitive to.